Welcome everyone to this new episode of the Privacy Rules Privacyespresso Series, a series of episodes where we discuss about the latest news on privacy, data protection, and in general about technologies. Together with me, I have an expert that is pretty different from the one that we normally have, that is Mike Swift. Mike is a journalist coming from MLex, that is an independent media organization that provides exclusive news and analysis on regulatory risk, also on sectors like privacy, security, data protection, but also M&A. You can check about MLex to see how many things they do on a daily basis if you want to know more about them. But among many things, Mike is also Chief Global Digital Risk Correspondent for MLex. So he's a very up-to-date person with everything that is related to this sector. So that's why I'm particularly pleased to have him with us today. So first of all, hi, Mike. Thanks a lot for being with us today.
Hey, Alessandro. It's great to be here. Thanks so much for the opportunity.
My pleasure. My pleasure. And, let's start immediately because I think you have a lot to share together with us. And, the topic we are going to discuss is one of the, classic topic of the moment, but very relevant, that is generative AI in particular. So we are almost 1 year into a wave of new litigation against generative AI. You've been studying a lot the litigation related to this topic. So what have we learned so far about this?
Yeah, it's been a momentous year, and we are expecting an even more interesting year going forward. We've essentially had pretty significant litigation filed against all of the major AI companies, and that includes OpenAI, Microsoft, Google, Meta Platforms, GitHub, and even smaller AI companies like Stability AI. One thing that we're seeing is that the real battlegrounds for these cases are likely to be in the Second Circuit, which is in New York State, and in Northern California, Silicon Valley, which is the Ninth Circuit. And we're not really sure. There's just in the past week, there's been a move by the plaintiffs in some of the California cases to try and get the New York cases transferred to California, so everything would be consolidated in California. We don't know what's going to happen with that, but we are now starting to see a few early decisions. These have been on copyright rather than privacy. And they indicate that from a copyright point of view, a few early federal judges in California have ruled that copyrighted materials that are used for training data may not be a copyright problem unless the copyrighted materials appear in the output of the AI, the AI query. So we have two decisions from two federal judges in California that have gone that way. So it's still early, but it's starting to give us a little bit of a sense of how things may be going.
Yeah, that's very interesting to hear, and I think that you've been raising a relevant point, that is the fact that the key issue related to AI is often copyright. This is something we were also discussing in our past Privacyespressos, because also, on the pure legal side with our members, we have witnessing many cases. And as you perfectly know, in many of those cases, the jurisprudence, let's say, and experience that we have into the court is very relevant also for the development of new law and further, guidance in the specific topic. So, in your opinion, which are the cases that have the potential to be, driving cases for the future for what concerns this topic in the US at least?
Yeah, the case that we're really interested to watch is the lawsuit filed by the New York Times against OpenAI and Microsoft. And this is filed in the Southern District of New York, so that's the federal court for Manhattan in New York City. It was filed the last week of December. So it's really too early, for any important decisions to be happening there. But what's really striking about that complaint by the New York Times is that they included 100 exhibits where ChatGPT spat out, when prompted by, a few words of a New York Times story, spat out almost verbatim the entire content of the New York Times article. There might be just a few words that were changed, but it is really suggestive of a real potential copyright problem there. So so far, there are similar cases that we're looking at affecting OpenAI and Google in the Northern District of California. But the New York Times case, I think, is going to be a really interesting one to watch.
Absolutely, also because it's related to something that is very sensitive and relevant, like public information and sharing of information, the newspaper. So it's very interesting. We have been witnessing or speaking so far about another type of copyright issues that was mostly related to images, for example. That is another big one. But this is definitely one of those cases, the one you were mentioning, that we should have a look at, and maybe we can receive an update from you in the future, let's say, whenever this is going to evolve. In this regard, we've been mentioning copyright a lot during this brief session. So do you really think that this is the most problematic issues related to AI, at least again in the US litigation framework?
Well, for those of us who are in the privacy space, we're now getting to the point where some of the privacy claims are actually going to be decided in some of these cases, and that's kind of exciting. Just within the last week, Microsoft, OpenAI, and Google have all filed motions to dismiss litigation against them, which make privacy claims. And we actually haven't written about that yet, but we expect to very soon. And these are motions that the court has scheduled hearings on in April and May. So we'll likely be getting those decisions back perhaps in June or July. And then we'll start to get a sense of whether privacy claims against generative AI models are going to have legs in the United States, and that'll be a very interesting and important thing to see.
Absolutely, thanks a lot, and absolutely, very often indeed, copyright and data protection and privacy in particular goes side by side in terms of cases that we see, at least for different sectors. But it seems like similar for generative AI in particular. We're still speaking about data and the inputs of data that are provided to the machine of the AI system. So it makes sense that they go side by side in this case. Mike, we are running out of our time, so I would like to thank you very much for this very quick and brief update on this very interesting topic, and I really look forward to speak with you very soon again. Of course, I would also like to thank all our listeners for being with us today, and looking forward to meet you all with our next Privacy Espresso. Thank you once more, Mike.
Thank you.